Court is back in session. The next argument is the estate of Michael A. Benyo versus Scott F. Breidenbach. Arguing on behalf of appellant is Scott F. Breidenbach. Arguing on behalf of appellee is Daniel Sager.
Good afternoon.
Good afternoon.
In the course of their divorce, husband and wife had signed a property settlement agreement in which wife agreed to waive all of her interest in husband's police pension. Husband died while the divorce was ongoing, and his pension continued to be paid to wife, who refused to transfer those payments, as contemplated by the terms of the agreement. Husband's estate sought damages from wife. Wife subsequently died, and her estate claimed that the agreement could not be enforced under state pension laws, prohibiting the attachment or transfer pension benefits. This argument was rejected in both the trial and the Superior Court and is the subject of the court's present consideration. Counsel may proceed.
Thank you, Mr. Justice. Please support. Good afternoon, Justices. Start, if I may, by wishing everyone good health in these days. Best health to your families. My name's Scott Breidenbach. I represent the state of Marcia Benyo. She is the substituted appellant in this appeal, which was initially filed by Marcia. This court to reverse the Superior Court's affirmance of the trial court's verdict, which ordered Marcia to, quote-unquote, transfer to her husband's estate each monthly payment she received from her annuity for the rest of her life. So the facts in our case are similar to those in the case of In Re Estate of Easterday, was decided by this court only last year. Our facts differ in several controlling distinctions and a reversal of the lower court's decision. Unlike the Easterday case, where the trial court's order, which is similar to our trial court, was found not to be precluded by preemption under ERISA. Our lower court order and our case is not a subject of preemption because it's not governed by ERISA. It is our position that the lower court order was precluded and prohibited by the state law police pension. Also, unlike in Easterday, where the enforcement action was litigated in the proper orphans court, which had exclusive jurisdiction over the estate's entitlement to funds arising from the decedent's death. Instead, our action was brought by the estate in the wrong division, the civil division, not the orphan court division, of the common pleas court, and the common pleas court of the wrong county, not the orphans court of Berks County, where a police chose to open the estate and petition for the grant of letters, but did not file this action there. Instead, brought it in the civil court of Chester County. Since the orphans court had exclusive jurisdiction, the Chester County court didn't even have jurisdiction to entertain this action. Moreover, the police pension law has not one provision which precludes enforcement or any court action against pension proceeds, but two provisions, Section 764 and Section 776, which not only preclude judicial or any other legal process, so the action couldn't even really be brought, but it also specifically precludes the order to my client to transfer those funds.
Mr. Breidenbach, we're going to proceed now since you've had an opportunity to open your argument with questions by the court, starting with Justice Doherty.
Thank you, Chief. Thank you, Chief. Counsel, let me ask you this. I believe it's your view that the language shall not be subject to assignment or transfer applies to the benefits. But how do you, let me rephrase it this way. The benefit was received by the beneficiary pursuant to the statute. How is it that you can articulate that that is not subject to assignment or transfer such that is rightfully your client's? Does that make sense to you?
I'm not sure that I understand the question, but my client was not receiving any pension benefits, although that's what they kept calling them. Section 881.102 survivor annuitant defines it. And it defines the survivor annuitant as the person named by the member, by Mike, by the policeman here, to receive an annuity upon his death. She received her own annuity. It was a joint survivor annuitant, how she's referred to. And that was her own asset. That was Palladino versus Palladino. The Superior Court specifically identified that White's survivor annuity is a vested property interest of White, separate and distinct from husband's pension. And although it's a result of the pension that she received that annuity, that she was entitled to receive it and was entitled to continue to receive it because it was not addressed in the contract.
I apologize. The last part you had broken up. I could not hear your last comment.
White's annuity benefits, or the benefit payments that she was receiving as a survivor annuitant. And her annuity was hers. Palladino versus Palladino, which is cited at 713 A2D 676, discussed in some detail the nature of a survivor annuity, and that it said specifically that it is a vested property interest of White, and it is separate and distinct from husband's pension. And that is what Section 881.102, which has the definitions of the Pennsylvania Municipal Retirement Law, and it defines the survivor annuitant, which was Marcia, and she is to receive an annuity upon the member's death. She was not receiving his
Are you finished? I don't know. I don't see your mouth. I don't know if you're speaking. I can't hear you.
Yes, yes. Are you able to hear me now?
Somewhat. I'm having audio trouble listening to you.
Marcia was receiving payments each and every month from an annuity, from a survivor annuity.
Okay, I got that. Okay, thank you.
Justice Wecht.
Thank you, Chief Justice. Good afternoon, counsel. In the QDRO that husband and wife signed, wife agreed to waive all right, title, and interest in husband's police pension. So I don't know where you're going with this attempt to distinguish annuity out of that. You yourself just used the word interest. Let me ask you, in that same QDRO, didn't the parties fully understand and anticipate the non-attachment bar of the pension laws when they wrote, if the plan administrator of said pension will not permit a waiver, et cetera, wife will agree to sign any necessary paperwork, including a statement, et cetera, that she waives the benefits and instructs her estate to make payment. Doesn't that show that the parties understood that they might encounter this transfer issue with the pension law and contracted around that?
I would submit, Your Honor, that the that provision, that sentence, was referring to death benefit. And it follows the sentence that is specifically referring to death benefit. And the sentence that you're referring to talks in terms of whether such benefits, if the plan administrator will not allow said benefits, I believe it said, to be waived. And the said benefits are referring to the prior sentence. At least that's my reading of it. And death benefits is something that the trial court did not, was not open to. That is that the actual pension plan is embodied in the statute of the Pennsylvania Municipal Retirement Law. Title 53, Section 881.101, 102 at SEC, that sets out the terms of the pension. And the term death benefits, which was used in the contract, has a specific definition under the law. And that definition, death benefits, is not Mike's monthly retirement allowance. That's not a death benefit. A death benefit is a lump sum payment, and death benefits to which a member is entitled is a lump sum payment of any money contributed by the employee to his pension plan. In this case, and the testimony at trial of the director of the PMRS was that there was no value for death benefit. Mike's death benefit was zero because he didn't contribute any money to that plan.
I do recall that. Counsel. Is it then your argument that by reason of that zero number, that the annuity is not a right, title, and interest in husband's police pension?
The annuity is not a part of a husband's police pension. No. Palladino versus Palladino discussed exactly that. It said that the annuity is wife's annuity. And it is separate and distinct from husband's pension. It may never come about. Her annuity could never have come about had she predeceased him. And if she had actually complied with the agreement, as it's written, the first sentence which says she will waive all title and interest in the pension, if she gave up her annuity, it wouldn't devolve to husband's estate. It would just disappear. So if she just gave it up and said, I hereby relinquish any claim I have to any benefit, any annuity or otherwise from my husband's pension, they wouldn't get those benefits. If she forfeited any claim to the death benefit, which had a value of zero, but if she had forfeited that, the estate wouldn't have gotten anything there either, which is why I argued that even if there's a breach of this agreement, there's no damages to them. And the pleading that was filed here sought equitable relief on the basis of a pleading that didn't plead any basis for equitable relief. The reason Easter Day was able to give equitable relief in the form of an affirmative injunction was because it was properly filed in the Orphans Court of Montgomery County. Here, both the trial court and the Berks County Orphans Court asked Appelt's counsel, isn't this in the exclusive jurisdiction of orphans court? And Appelt's counsel said no. Reason is because under, as in Easter Day, where section 3323 of the divorce code provided that if grounds were established, then it's decided under the divorce code. Well, section 3323, subsection E or F, I believe, grants all equitable powers to the court to fashion whatever remedy it wants. Well, clearly grounds were not established. But if counsel had taken this to the orphans court, then the orphans court would have had all of the panoply of equitable powers that it had. However, because it was no longer in the divorce court, the wife, my client, would have then been able to pursue her rights to her elective share. And that, I submit, is why the estate did not pursue the action under 6111.2, which said if grounds established, it then proceeds in family court. And if grounds were not established, then it's decided under the orphans court umbrella. And the orphans court umbrella has equity powers, so does the family court. But this civil trial court, which made a point to say this is a pure contract action, but the pleadings didn't plead anything that entitled it to equitable relief under pure contract law. And the court, in the notes of testimony, there was a 2-hour discussion among counsel and the court, and argument, where the court set out and in fact granted our motion to dismiss the equity count. The court then came back after a recess, and without explaining why, said that it reversed itself. The court said, I'm reversing myself, and I'm going to let everything go to the hearing. And by the way, Your Honor, there was no QDRO here relating to husband's pension. There was a QDRO entered into divorce case relating to my client's 401k, which the court did not have jurisdiction to enter, but that goes beyond what this argument was granted.
Well, we're closing in on your time limit, so we may have time for a brief question by Justice Mundy, should she have one, and then when you complete that, we'd ask you to conclude your argument.
Chief, I still have a couple questions.
What?
Justice Bear, I still have a question. I haven't had an opportunity yet.
You can have my time, Justice Bear.
That's not necessary. You have no questions, Justice Mundy? I have some questions, Counsel, and Chief Justice, thank you for permitting this. First of all, with respect, your argument apropos of Chester County divisions is nonsense. Chester County, under the Pennsylvania Constitution, has no divisions. It's a court of general jurisdiction. It has jurisdiction over both the people and the subject matter. So don't waste my time with that. If I understand your argument more specifically, that has perhaps a little more relevance, you're trying to distinguish between a death benefit and a survivor annuity. Is that fair?
Yes.
Okay. And if I look at the language of your contract, it says that wife will sign any necessary paperwork. She waives any benefits. If she's to receive any benefits designated by husband, etc. Now, I understand your argument that the word death benefit's there, but isn't the fair intent of the parties from this contract that what she was going to get from the husband at his death, regardless of what label you want to put on it, she assigned to the brother-in-law? Isn't that what she intended?
I believe that's what they intended. I believe that's what Appelt's counsel intended, who drafted the document. My client was
You're being a good lawyer. You're trying to sneak out of it. But
No.
that's what your client intended when she did it.
I believe that was their intent, was that it be assigned. And assignment of those benefits is illegal. It's
If your client gets the money, and I don't care what you call it, it's in her pocketbook, can she take it to Vegas and waste it once she's got it?
yes, but she can't be subjected to legal process and compelled to take it to Vegas.
Can she assign it to a third-party beneficiary?
No, I don't believe she can.
Why not? If she can go to Vegas, she can use it for toilet paper. Why can't she assign it? It's hers.
Because the statute says it's not assignable.
It's assigned, and this is what Mr. Christine said. I couldn't tell whether Sean was a male or female name.
It was a male.
It's a male. Mr. Christine said, once it's in her hands, we don't care.
That's the Pennsylvania Municipal Retirement System. This case involves the Pennsylvania police law. It is administered under the PMRL, but it has.
All right, and you'll excuse me for interrupting, but my time is about to run. Your position is, and again, I'm trying to ferret it out so I can go back and look at it. Under the municipal police law, even after it's in her hands, even though she can go to Vegas with it, she can use it for toilet paper, she can't assign it to her brother-in-law.
That's correct. That
Okay.
under the police pension law.
I got it. Thank you very much for your time.
Thank you. Your 20 minutes, which we've allowed you, is up. So we're going to hear from counsel for the appellee.
Thank you.
Thank you. May it please the court. Our argument is as follows. I believe appellant
Would you
is
tell us who
correct.
you are, sir?
I'm sorry. I'm Daniel Sager. I represent the estate of Michael Benyo.
Thank you.
Our argument is as follows. As Mr. Breidenbach for the appellee stated, the annuity benefits at one point were property of through a divorce. It was marital property, and if there was no agreement, it probably would be property of not probably, it would be the property of Ms. Benyo and ultimately to her estate if it continued, which it did not in this case. However, the parties entered into an agreement, and for decades, this court has stated as long as there if there is a contract, and as long as it is not a contract of adhesion, coercion, duress, fraud, misrepresentation, a contract is a contract. And you stated that in your most recent case in Esterdy as well last year when you made that decision. If you read the four corners of the agreement, and if you read the testimony of Ms. Benyo as well, it is inconceivable that the parties thought that Ms. Benyo, if Mr. Benyo were to die, was to receive the benefits, or she can just terminate the benefits and it would not go to Mr. Benyo's estate or his brother-in-law, as stated in the agreement. You read the agreement as a whole, review the record, they actually follow through with the agreement in all its entirety, including a Kudrow for a 401k, changing right title and interest in a marital residence, personal property. And by the way, they couldn't do a Kudrow, as Mr. Breidenbach states, because A, it's not under ERISA, which we concede, so it would have to be a domestic relations order. But second of all, because it already was in pay status. And that's what Mr. Christine states under in his testimony. They would not even accept a domestic relations order because it's already in pay status. The only way you can get the annuity to another person would be through the agreement as stated. And therefore, this what the trial court stated and the Superior Court affirms, it should be followed by this court.
Thank you, Mr. Sager. We'll begin the questioning with Justice Todd.
I have no questions, Chief Justice.
Thank you, Justice Shaw. Justice Donahue?
Good afternoon, Counsel.
Good afternoon.
I'd like to focus on what I believe is the only issue that we granted allowance of appeal on, which is the meaning of the language of the statute at issue here, which is the municipal police pension law. So the section 764 precludes. Let me just read you because it's very short, and I'd like your interpretation of what this means. Retirement allowance herein provided for shall be payable only to the beneficiary designated in this act and shall not be subject to assignment or transfer. Let me tell you how I read this statute, and you tell me if I have missed something. This precludes the plan administrator from making payments to anyone but the beneficiary, and it precludes the plan administrator from accepting an assignment so that it should have to make payments to someone other than the beneficiary. Do you agree with that interpretation?
Yes, I agree with that interpretation. What it doesn't do is it does not preclude, once payment is made to the beneficiary assigning the monies they receive to a third party, or go as Justice Bayer had stated, to Las Vegas or pay for the toilet paper. There's nothing that precludes one from doing that or entering into an agreement that state. And Mr. Christine also testified that way.
I agree. So you're in agreement with me as to what this section of the statute says. Let me take you one step further, because there is another question of statutory interpretation in this case. And once again, this is what we accepted allowance of appeal on. Section 776 provides that payments herein provided shall not be subject to attachment, execution, levy, garnishment, or other legal process. Are you familiar with that statute?
Yes.
And it goes on to say, and shall be payable only to the member or his designated beneficiary, and uses language again, shall not be subject to assignment or transfer. As I read this statute, this precludes any interference with these funds before the funds reach the beneficiary.
Correct. That's how I read it as well. And that's what the case law, as I review, says. And
then the phrase "and other legal process" therefore refers to any other legal process directed either to the plan administrator or, for example, the bank in which the funds are deposited.
Correct.
For example, an injunction or a declaratory judgment.
It's primarily, you're correct, for creditors, to prevent creditors from attaching onto the annuity or the pension benefit or garnish it.
Okay, so it does not speak at all to what the beneficiary can do with the funds once it's in their pocket.
Correct.
Okay, thank you.
Thank you. Justice Dougherty?
For clarity purposes, your indication is that the non-alienation doesn't apply because the money was received by the right participant, and therefore anything done thereafter would be subject to the property settlement. Is that correct? Okay.
As long as it does not conflict, and it does not with the Pennsylvania municipal pension laws, which it did not. As Justice Donahue states, it could not be garnished directly, as did Mr. Christine testified. Yes.
All right, I got it. Thank you.
Thank you, Justice Wecht.
Thank you, Chief Justice. Counsel, so that as long as the beneficiary has good funds, any legal process could ensue thereafter and not be in violation of these pension provisions. Is that correct?
Correct.
Thank you.
Justice Mundy?
No questions. Thank you.
Justice Baer?
And I'm following up. I guess we're all beating this same dead horse just because of the other side. You concede that once this money has been paid to her, the survivor annuitant, been paid to former wife, deceased wife, it can be garnished?
Yes,
It can be attached, whatever,
sure.
because it's hers. Is that right?
Yes, correct.
Okay. I understand as well. Your agreement with wife's estate entitles you to counsel fees. And I know the trial court gave you counsel fees, but you have substantial counsel fees, I would presume, in preparing and arguing to us. Do you want this case remanded if you prevail, if the majority of the court sees it your way, to obtain additional counsel fees from the other side?
I would ask that if that were the court's decision, that there would be a determination for the lower court to make that additional relief. What the Superior Court did, because of Ms. Benyo ultimately dies, remands it to the lower court for a change in damages anyway, because obviously there's a change in damages. So,
So
yes.
you have an opportunity to seek fees. We don't have to specify that. It's
Correct.
going back. If you prevail here.
Correct.
I have one other question. I can't remember. Chief, I'm done. Thank you.
Thank you, Justice Barrett. Justice Todd, anything else?
Nothing.
Thank you, Justice Donahue.
No, nothing.
Okay, well, thank you. If you'd like to say a word or two by way of summation, we appreciate the succinctness of your argument, Mr. Sager.
I'll be very, very brief. I just ask that this court affirm the decision of the Superior Court and remand it to the lower court merely to determine the damages.
Thank you. Thanks to both of you. And that'll conclude argument. In that case, we're scheduled to commence argument in the final case at 1:15.
Thank you.
That concludes my business.
The next argument is in the matter of Catherine F. Leight versus the University of Pittsburgh's Physicians, UPMC. Arguing on behalf of appellants is Mark J. Homiak. Arguing on behalf of appellees is John C. Conti.
Good afternoon. Appellant was injured in a shooting while he was employed at Western.
The next argument is.
She and her husband sued various medical entities, alleging that the shooter's physicians should have taken steps to have him involuntarily examined, and that their failure to do so constituted gross negligence, subjecting them to liability under the Mental Health Procedures Act. The trial court granted the medical entities preliminary instructions, and the Superior Court affirmed, concluding that the physicians treated the shooter on a voluntary outpatient basis, and that such treatment fell outside the scope of the Act. The court allowed appeal to evaluate this holding. Mr. Homiak.
Thank you, Your Honor. May it please the court, I'm Mark Homiak, and as you know, I represent Catherine Leight, the most seriously injured surviving victim of John, a severely mentally ill person who conducted the Western Psych mass shooting incident. Mrs. Light's claims are strictly based upon breaches of duty imposed upon the shooter's physicians by statute, the Mental Health Procedures Act. First, the lower courts were in error because a Section 302 involuntary emergency mental health examination is obviously involuntary. MHPA Section 114 specifically allows recovery for damages caused by doctors' grossly negligent participation in involuntary examination decisions. As the Chief Justice noted, the trial court ruled that Section 113 excludes voluntary outpatient mental health care, not medical care, and therefore ruled that the claim was outside the scope. The operative facts are that the doctors decided their patient required Section 302 involuntary examination and treatment because he was a severely mentally ill person who was a clear and present danger of harm to others. As the MHPA's first step in the involuntary treatment process, the complaint averts facts establishing those decisions were grossly negligently executed. One minor correction, the doctors did take steps. What they didn't do was execute their decision to cause the involuntary exam to actually occur. And if a member of the court doesn't find it self-evident that a decision that a person requires an involuntary mental health examination involves involuntary treatment under the plain meaning of the MHPA Section 103, please ask a question allowing me to clarify that. The second reason that the trial court used to dismiss the complaint against the doctors was that the doctor's liability for their grossly negligent execution of involuntary examination decisions cannot be considered unless and until the doctor signed the document that would have caused the examination to have occurred. Yes, that's what I said. Respectfully, this shows a fundamental misunderstanding of the structure of the MHPA. The lower courts got the MHPA statutory scheme backwards. Other than the Section 302A2 right of a peace officer or doctor to physically take the person to the facility for examination, the Act requires that each time any event occurs involving any involuntary mental health treatment, a document must be signed. If doctors grossly negligently decide to prematurely discharge a mental health patient from commitment, as in Goria, Shirk, or DeJesus, they do not sign the commitment extension document.
Thank you, Mr. Homiak. With that opening, we'll begin the questioning, starting with Justice Wecht.
Thank you, Chief Justice. Good afternoon, Mr. Homiak.
Good afternoon, Your Honor.
I wonder if you could identify for us the point in time or the particular action at which juncture the MHPA came into play In other words, to pinpoint the decision that brought the care of Mr. Schick under the MHPA's coverage?
Certainly. Friday, February 10, 2012. At that point, Schick came into the office of the family practitioners carrying a baseball bat, as he had been doing in recent times. He took the baseball bat and was banging it on the counter and threatening the staff and the doctors. Two of the physicians that were there observed it. One of them called Western Psych's outpatient unit Resolve, reporting that Schick had been out of control with his mental illness recently, threatened them with the baseball bat, and requesting commitment assistance. The Resolve is what they call it, the outpatient unit staff, went to Schick's apartment. Schick wouldn't let them in. They tried to call the doctor, and the doctor was no longer at the office. So then on the following Monday, February 13th, Resolve, as it's called the doctor again, said, we couldn't commit him because we didn't hear it from you. Only the person who took the call heard it. Therefore, we need to hear it from you. He said, I'm going to report it to my UPP supervisor. Longer at 4 days later, Schick's mother called UPMC Shadyside family to report her concerns about Schick. The doctor who made the first call, his supervisor, and another resident physician discussed the situation. The same doctor, Dr. Weiner, called Western Psych asking to have involuntary commitment papers for Schick faxed to him. So
if I could just interrupt to follow up, Mr. Homiak, excuse me. But I understand there's, and from your brief, there's obviously an avalanche or a cascading set of facts here. My question is, my follow-up question is, in the absence of the bright line, which Aplt tells us the statute embodies, i.e. the act itself of the involuntary commitment commencing the coverage, what would you suggest that this court offers as the standard to govern the law in this area for when the MHPA coverage exists? Because obviously you've articulated facts that will enmesh courts in a pretty substantial gray area with the potential for differing outcomes. And since this is not like a Tarasoff common law claim, it's important that the lower courts understand when the statute's coverage applies, not just what happened with Mr. Schick.
I would suggest that the line is, once the doctors evidence their decision that the person must undergo it, and in this case, they evidence that decision by making the first call, asking him to be committed, by asking for the documents to be faxed to him, and finding out that they wouldn't be faxed, and then refusing to go the 5 miles from Shadyside to Oakland to sign the document. And then finally, the third time, when the doctor said to the Resolve person who was going to come to him to get it face to face, and he said, no, I've changed my mind. I don't want you to come here anymore. I'll go to Western Psych tomorrow, and then didn't. Now, I'm not as articulate as the members of this court in answering your question. I don't know how to say it other than when you look at it, you know what it is. These doctors decided he needed it, took steps to accomplish it, were told, no, you have to come in and sign, and then refused to do so. I don't know what you'd call that other than there's evidence that they reached a decision, attempted to cause it to take place, and then refused to take the steps that were pointed out to.
Justice Mundy?
I have no questions at this time. Thanks.
Thank you. Justice Bear?
Mr. Homiak, do you have to, in your estimation, get by Section 103 scope of the Act before you go any further in analysis?
I believe the 103 scope analysis was not properly taken here because it's an involuntary
But that's not respectfully, because my time is limited, so I'm trying to stay channeled. Do you read the statute that if you do not, your client, that the injury, that the Mental Health Procedures Act 103 is not applicable to your client, regardless of your argument as to whether it is? If it's not applicable to your client, you're out of court. I understand you think it is.
I have difficulty understanding your question, sir.
I look 103 and it says MHPA scope of the act.
Right.
If I read that and conclude that your client, that the mentally ill individual is not within the scope of this act, does that end the inquiry here?
It would. If you would decide that that 103, providing that anytime there's outpatient mental health care and that the involuntary examination is not within the involuntary treatment that clearly is within the scope of the coverage, then that would end it.
So is and again, I hate to be in a hurry, but my time is limited, and I want to decide this correctly, so I'm trying to understand the argument. So I feel good about my vote, regardless of where it is. What under 103 encompasses this seriously ill individual? Is it that he was involuntarily treated, that he was an inpatient, involuntary inpatient or outpatient, or that he was a voluntary inpatient?
It was that his physicians were initiating the involuntary treatment.
So you would encompass, and I appreciate this, you would encompass the initiation of treatment as the right and procedure for involuntary treatment. Is that fair?
Yes, it's what it is.
Okay. Thank you for that. The other thing that concerns me here is where you draw the line. A typical patient who's got some not too serious depression or beginnings of sundown syndrome or the like goes to see their PCP, and the PCP writes in the notes some concerns for the psychiatric welfare of my patient, etc. Does not follow through. Liable under your theory?
No, sir, because
assuming that the patient goes out and shoots somebody. Go ahead.
Because there were 30 of those at least in the 4 months or so leading up to the point in time when the medical records of John Schick reflect that the doctors decided he needed to be involuntarily examined and committed and treated.
And thank you. And my question then to you is, how do you draw the line between that scenario and the scenario with liability? I mean, if I look at your statement of the issue, you set forth 4, I think it is, different criteria, not susceptible to a Supreme Court opinion. It's really a sui juris example you set forth. So where do you draw the line between, I have some concerns for the psychiatric, and I am going to be, not that I'm grossly liable, grossly negligent, but that you can get a case to a jury?
I can get a case to a jury because this is involuntary treatment and therefore within the scope of the act. And specifically, it's specifically prohibited that a physician cannot grossly negligently deal with an involuntary examination decision.
So the doctor has to take some steps towards involuntary commitment and not follow through. Is that right?
Correct.
Okay. Fair enough.
That can happen.
Thank you. Thank you, Chief.
Justice Todd.
Thank you, Chief Justice. Mr. Homiak, I'm trying to follow up on the drawing the line problem that Justice Baer articulated. And the issue, as I see it, is were we to draw that line anywhere short of the actual language involuntary treatment, then it's a very gray area for us to apply to the whole Commonwealth. Obviously, our decision is not just about this case, albeit this is a very important case, but our decisions also impact the rest of the Commonwealth. Here, you have a situation where he should have been committed. He should have been involuntarily committed. The doctors recognized that, but did not implement, did not fully execute the involuntary commitment. So they made, at least one doctor made the decision, yes, he should be involuntarily committed, but then apparently either didn't follow through or changed his mind. As long as we're in that gray area up to the execution of an involuntary commitment, I don't know how we could draw that line as a statewide policy.
Well, respectfully, I don't see how you can't say that calling Western Psych and saying, please commit this patient of mine, he is severely mentally ill and a danger to others, is not the initiation of involuntary treatment.
But didn't you indicate that the doctor later changed his mind?
I don't know what caused him to not follow through. What I know is, and it wasn't just one, that first doctor said that he needed to have him committed, but then he left the office, and so he didn't get the call. And then on Monday, he was told, well, we couldn't do it because we couldn't get in touch with you. And he said, okay, I'll report it to my superiors. Then that same doctor later sent the fax saying, or asked to have a fax sent to him, pardon me. And they refused. They said, you can go down to Western Psych and sign it. And he didn't. And then the third one, he said, he needs to be committed. They said, we'll come out to you, but we're running late. He said, don't worry, I'll go tomorrow. I don't know how those three actions are not the initiation of the involuntary examination process.
All right, thank you.
The best answer I can give.
Thank you.
Justice Donahue?
Counsel, if I'm understanding your position, once a physician who was actually treating this particular patient, once that physician makes the therapeutic decision that the patient needs to be involuntarily committed, that triggers the coverage of the Mental Health Procedures Act. Is that correct?
I'd say that's a little broader than what I'm asking for. I'm asking for once the physician makes that decision, then acts on it, but grossly negligently fails to execute it, that's the point where liability attaches.
Okay, thank you.
Justice Dougherty?
I can't hear you, Justice Dougherty.
Can you hear me now? I apologize. Yes. I see this case somewhere falling outside of Dean and Allen. In Dean, this court made the decision that drug treatment does not fall under the mental health. And in Allen, this court found that coincidental treatments do. Here, we have an individual with a purely mental illness seeking treatment for mental illness, and ultimately, that was through a voluntary basis. The doctors or the medical staff don't follow through with the involuntary. What it appears you're asking us, and correct me if I'm wrong, is you're asking us to find that medical staff fall outside the protection of the act because of a patient's lack of participation, or let's say being just non-compliant. Is that what you're asking?
No, sir. And in fact, Schick wasn't seeking mental health treatment. Schick's mental illness prevented him from believing that he had it, even though he had been committed on 5 extensive commitments previously. Schick did not believe it. It was suggested to him over 30 times that he voluntarily go get the treatment he needed. He refused. And any involuntary commitment case, that's always going to be the situation. What happened here, unlike in the Dean case, is that the doctors decided that he did that and then grossly negligently failed to execute the involuntary exam. If I may address Dean in one other respect, what you writing for the court stated was that we had to look at the facts comprising the material acts and omissions of the parties must be applied to the plain language of the MHPA as well as to the act's purposes to resolve the Section 114 applicability issue. The policy of the MHPA, as outlined in Section 102, is to make involuntary treatment available where the need is great and its absence could result in serious harm to the mentally ill person or others. And that's exactly what happened here. Mrs. Leight suffered her gunshot wounds because these doctors did not effectuate the policy of the MHPA, and by not grossly negligently executing their decision that he required involuntary treatment.
Thank you, Mr. Homiak. Thank you.
Thank you, Mr. Chief Justice.
Mr. Conti.
May it please the court, John Conti for the defendants. This appeal presents an issue of enormous importance to the medical community and to society as a whole. The issue is, under what circumstances can a physician be held liable to third parties for a criminal act of violence by a patient? Plaintiffs are advocating for an astonishing expansion of current law as they seek to hold a family practice physician liable for a mass shooting merely by making an allegation relating to the physician's thought process that he decided to commit the patient. There exists no law duty to commit, and therefore plaintiff's effort to predicate duty on an alleged state of mind is frankly an absurd, even dangerous proposition and should be rejected. As this court has intimated in this questioning and in many cases, there needs to be a bright line demarcation for when the process for involuntary commitment begins. And that is so because the procedure involves a profound deprivation of an individual's liberty. And the statute does provide for those precise, exacting, clear, and unambiguous steps. The statute provides that there must be a writing in the form of a certification, an application, or a warrant before or accompanying the examination of a person for involuntary commitment. Not superfluous paperwork, as the plaintiff alleges, but rather as the foundation of the patient's constitutional right to due process in the face of the government's attempt to forcibly confine him. Plaintiff, in their proposed question for this court's review, mentions the case Goryev as their lead precedent. In fact, Goryev is not remotely analogous to the instant case. Goryev involved the affirmative discharge of a patient who had been adjudicated a clear and present danger, who was involuntarily committed, and who was under the care of mental health practitioners in a locked psychiatric unit in a facility over which they had complete control of him. Under those circumstances, there is no analogy to be drawn. And finally, I would invite the court to understand that we are appreciative of the court's demonstration and other opinions of the challenges faced by mental health practitioners, including the fact that violence is impossible to predict. This court's approach has been cautious and incremental, as for example, in Emory. And with this in mind, I respectfully urge that the court exercise restraint and consider the profound unfairness in imposing such expansive third-party liability on medical professionals for the criminal acts of others. Thank you.
Thank you, Mr. Conte. Justice Wecht.
Thank you, Chief Justice. Good afternoon, Mr. Conte.
Good afternoon.
Putting common law Tarasoff type scenarios to the side, focusing on the MHPA here, is there anyone, physician or otherwise, that you believe would have an affirmative obligation under any scenario to seek out an involuntary examination under the MHPA?
No, Your Honor. The question, as you said, is subsumed under the notion of creating a duty to commit. And for all good reasons, there is no such duty, because the converse of any such duty would be it would open up to liability that individual, unlimited liability for violent act committed by the patient.
And just a brief follow-up, sir. is it your position that there could never be a circumstance under which a decision not to seek I'm talking only under MHPA, not under common law, that there's never a scenario under which a decision not to seek an involuntary exam or a halfway bungled attempt could ever allow for liability under the Act?
If I understand your question correctly, I would answer that the involuntary commitment process, as set forth in the statute, is a multi-step process. So hypothetically, if for a warrant to bring for an exam, and could be that the warrant is not granted, that could be alleged to be grossly negligent, and that may be the cause of action. So there are steps within under the Act that, if not executed properly, could give rise. But those steps are triggered only once the formal procedures are begun.
Thank you.
Justice Mundy.
Good afternoon.
Good afternoon.
I just have a little difficulty in understanding your position that the Breidenbach case has no bearing here. My understanding of that case was that the patient had been involuntarily committed. The decision was made to discharge him out into a voluntary treatment scenario, in which he committed a act of violence on a third party. So, to my view, Breidenbach stands for the proposition that the discharge treatment or the discharge of a patient falls under the Act. So, if you flip it on the other end, why doesn't the admission process?
The 2 points, Your Honor. First of all, it was not the, quote, decision to discharge that created the exposure to liability. It was the act of discharging the patient. And by that, I mean decision, as you might be using it, reflects a state of mind or a thought process. Had there been a hypothetical decision to discharge without the act of discharging, there would be, because there would not have been any harm. That's the first differentiating point. The second, and this goes back to this court's analysis of the duty of psychiatrists as articulated and examined in the Emmerich decision. The notion of control has great bearing on the expansiveness of the duty the court implies to mental health professionals, and certainly here to family practitioners. Thus, in Goria, the patient, again, having been adjudicated a clear and present danger in a locked psychiatric unit under the complete control of mental health professionals, is light and day different when they decide affirmatively and then they act to discharge him from a family practitioner, as the lower court said, giving consideration, giving thought to admission, to commitment. The two are night and day different for those reasons.
Is the admission process for involuntary inpatient treatment part of the involuntary treatment?
The admission process for involuntary treatment, I think, I'm not quite understanding that concept, because involuntary commitment requires this emergency psychiatric examination at a approved facility, which must be accompanied by documentation supporting its necessity. Those are ironclad, bright line requirements. So if they're not present, again, these are constitutional due process protections. They're there to protect the patient. If they are not present, the procedure has not begun under the statute.
All right, thank you.
Thank you, Your Honor.
Justice Bear.
Thank you, Chief. I want to continue on the same line as Justice Mundy, as I had the same thought. If I understand Mr. Homiak's argument correctly, he looks at 103, which says the Act establishes ... procedures for all involuntary treatments. And he says the initiation of the procedure. The telephone, the requesting that the documents be faxed, the call to resolve, or the initiation of the involuntary procedure, and puts this case under the scope of the Act. And I think that's what Justice Mundy's asking you. And tell us again why that's wrong.
It's wrong because it opens the door to unfathomable ambiguity and confusion about when the process for involuntary commitment begins. Were the court to accept that proposition, a physician in his office, a pediatrician, a family practice doctor, wouldn't know that by merely discussing a commitment, or asking for advice or doing some due diligence wouldn't be triggering liability on his part. Physicians and patients are entitled to clear guidance, and respectfully, those types of acts simply do not allow for the court to articulate any bright line, broad principle that would suffice to provide mental health practitioners the guidance they need.
Mr. Conti, let me, because my time is short again, I understand your answer. And frankly, I concur that your clients have a terribly difficult job here. But you tell me, where do you draw that broad black line, which when crossed provides that you're within the scope of the Mental Health Procedures Act? Is it when you sign an application? It's when you go to testify? When is it?
Your Honor, that has never been decided, of course. I would proffer to the court that the appropriate way to determine when voluntary outpatient care transforms into involuntary care would be when the individual's liberty has infringed upon, as for example, when the individual would be taken by police or others involuntarily for the mental health examination, and certainly thereafter. But it is deprivation of liberty, which to my mind would represent the trigger for the application of the involuntary commitment or involuntary care aspect of statute.
Thank you. Thank you.
Thank you. Justice Todd.
Thank you, Chief Justice. Mr. Conti, it seems to me that your best and clearest argument, regardless of policy considerations and the difficult job that the physicians obviously have, is simply the plain reading of the Act. And that's what the trial court said, and that's what the Superior Court affirmed. It seems to me that it's a simple question of, is this covered under the plain meaning of the Act? And I understand your argument is no.
I'm sorry, it is covered by the plain meaning of the Act. The Superior Court, again, dealt with the issue in 2 or 3 sentences, saying that merely thinking about the commitment or considering it doesn't constitute action under the Act. I would point something else.
You misconstrued my question. I'm sorry. In looking at the plain language of the Act, the plaintiffs, you're saying the plaintiff's allegations do not fall within the plain meaning of the provision.
Absolutely. There's no question that he was at all times a voluntary outpatient. And I don't think there's any question that the formalities, the strict requirements of the Act were not complied with or initiated. What I wanted to point out was that it's very interesting that when they went to the Supreme Court, the plaintiff completely changed their argument. If you look at the Superior Court opinion at page 17, they cite the errors that plaintiffs claims to the Superior Court. And this is on page 17. The plaintiff's claim was that the defendants never initiated the commitment process. When they got to the Supreme Court, the claim became a little fuzzy. It became they initiated it or decided to do it, but they didn't complete it. And it, again, it points to what I suggest is really a way of trying to conjure a common law claim out of a statute.
Yeah, and your answer simply is the line should be drawn with the deprivation of liberty.
That would be the most, I think, logical and compelling place to demarcate where voluntary and involuntary care transition.
Okay, I have one final question, and this may sound like these may sound like fighting words to you, but I just want you to tell me: is this provision an incentive for physicians not to involuntarily commit?
No, not at all, Honor. I think that physicians understand, first of all, the enormous burden that's involved in bringing about commitment. They understand the goal of the act, and which has been the goal of society for a half a century, which is to treat mentally ill patients in the community, and that with the least restrictive alternative. So I think society's structure that has been imposed on physicians, and which limits what they can do and can't do, that really forms their view about commitment. And I don't think at all there's a sense of or a reluctance to commit if they felt it would be helpful, if they felt it would be necessary, if they felt it would be granted. But again, it's been deemed by the legislature and the courts to be essentially a type of limited temporary last resort.
Thank you, Mr. Conti.
Thank you, Your Honor.
Justice Donahue.
Thank you, Chief. Mr. Conti, I'm looking at this from maybe a little bit of a different angle here. I'm looking at the immunity section of the Act, 7114.
Yes.
And from my perspective, our General Assembly would not be immunizing conduct if there was no liability in the first place. Do you agree with me?
Certainly.
Okay, so if we look at the language of the immunity section, as I read it, it anticipates conduct for which there may be liability that precedes the actual involuntary commitment, which is where you're asking us to draw the bright line. And let me give you an example. There are two. And I've sort of I've added ellipses for our purposes since we're dealing with a physician, but it provides immunity for a physician who participates in a decision that a person be examined or treated under this act. That, to me, contemplates conduct that will be taken in the future. Certainly, it can encompass the actual commitment procedure, but that's not what it says. It says it's immunizing a physician who participates in a decision. Okay, and let me just finish, and then you could answer sort of globally. I then look at the last phrase of the immunity section, which provides immunity for a physician who denies an application for involuntary examination and treatment. So in that case, there would never be a commitment. So why would the General Assembly be immunizing this conduct where under your analysis, there's no liability in the first instance?
Your Honor, my answer is they're not immunizing the conduct if the conduct, as articulated in the section that you're referring to, occurs under the Act. The phrase under the Act, participates in a decision under the Act, is what 7114 says. And under the Act, clearly to me, means under the provisions of the Act for involuntary commitment. It in no way contemplates that a, quote, decision, as that term is used, would imply conduct of a physician at home or just anywhere, in the office engaging in a conversation or a contemplation of something. That would be, I think, a very unsound way to view that. It must be viewed in total.
But I'm sort of focusing on our job here, as we all have been, which is to give meaning to this concept of what an involuntary or voluntary commitment or an involuntary treatment decision is. And how about the second point, Mr. Conti? How could it be oh, go ahead. You're getting your papers, I could tell, because I didn't see your top of your body. The final phrase of the immunity section provides immunity for a person who denies an application for involuntary examination and treatment. There's never been a 302 in that context. So why would that conduct be immunized under your analysis of the act, where you bright line need that commitment procedure to begin in order to have any liability?
Your Honor, as to the last point, I think all the legislature did was to indicate that certain officers of the court cannot be held civilly liable for decisions made with respect to involuntary commitment. And to answer your point about the other meaning of this provision, I argue vigorously that all of those provisions imply logically that they must be within the procedure outlined by 7302. Stated another way, what it says is if and when you begin the procedures for involuntary commitment, you have to do them correctly. And
Mr. Conti, if I could just interject there, I keep referring this to an immunity provision, but as to that last phrase that I just read to you, if a plaintiff could establish the gross negligence or recklessness that's required, that position could be liable. I mean, so if this were a pure, I would understand if it said all that's saying is you can never be liable. But that's not what it says. This is included within the same provision that says you can't be liable unless you prove this elevated standard of conduct. And so that's what I'm saying. I mean, I understand how we've actually not been called upon to answer the question that you brought to the court, or Mr. Homiak has brought to the court, which is, when does this act's provisions attach? And just from my perspective, I think it's reasonable to look at what the General Assembly thought they had to immunize that would otherwise incur liability under the Act.
If that would open the door to claims that would be indistinguishable from a claim under common law liability, then I would say that would be unsupportable. And that's what I think that interpretation would open the door to.
I don't understand how that is, because I'm just straight out reading the language in the statute. I mean, at some point in time, that's what we end up doing. We end up looking at the statute and say, is it ambiguous? Do we look to the immunity section to define where the coverage of the Act applies? And so, maybe as I work this through, as time goes on, I'll come to the point that you can. But right now, I'm just looking at the statute to help me understand what the appropriate resolution of this question is as to when the procedures of the Act apply. But I thank you for your input. Thank you.
Thank you, Your Honor.
Thank you, Mr. Conte. The time is up, but I would like to, before we conclude, ask Justice Dockert if he has a question.
No, my question was exactly that which Justice Donahue inquired.
Thank you. Thanks to, and believe me, Mr. Conte, we understand your argument. It's been articulately presented and briefed. So we're going to conclude now, and with thanks to both of you.
Thank you very much, Your Honor.
Thank you.
Chief Justice.
You're in court, Brian.
Adjourned.